Hello, welcome. It is another LawyerFair legal podcast, and today the issue of IP, in which probably the majority of your value is tied up. So it's an area of some business critical importance. And today we're joined by one of our panel experts, Savva Kerdemelidis, who is an IP legal advisor with, I think, over 10 years' experience advising technology and software companies. And Savva walks us through some of the areas that are particularly important to consider and also looks at issues like patent trolls, which is certainly something that was fairly new to me in advance of the conversation. So without further ado, we'll take it away.
Send lawyers, guns, and money. Hey! Send lawyers, guns, and money.
Welcome and thank you for joining us on the podcast today.
No problem. Thanks for inviting me.
Not at all. Well, a number of companies, technology companies in particular, that come on the platform, IP is definitely a key issue for them. And the headline of this chat is the protection and enforcement of IP, and it's an area obviously you specialise in. So just give us a little bit of background about the kind of companies you work for, the kind of work that you do, and some of the key issues that come out of that.
Okay, so I've set up EU Law Online as a legal consulting firm. We mainly do commercial and IP, and we specialise in servicing technology companies. And IP is something that does come up pretty often with technology companies because it tends to be the main product that they deliver, and it's also very important, obviously, to have protection around that, especially when you're looking for investment. Investors like to see that you've got at least some sort of IP protection in place. With software companies particularly, they tend to just rely on certain types of IP like copyright, which can arise automatically, but there are some issues around copyright, particularly around licensing, and which tend to be overlooked. And patents is quite an interesting area. It's more for hardware technology companies, but also it can have a place for software, and especially there are some issues in the US around freedom to operate and a lot of software patents being used, particularly against buying incumbents to prevent competition.
So just a quick question on that patent thing, actually. This was something that raised recently with us, was the issue of patent trolls. I know there's a slight tangent maybe to what you were saying, but
yes.
I hadn't fully appreciated the danger of kind of patent trolls. Are you aware of them, and what's your view on that issue?
So patent trolls, it's an increasing problem. Like the number of software patents has skyrocketed in the past decade. So it's and one of the main issues is that and there's been a bit of a swing back. This is particularly an issue in the States against software patents because it's creating what they call a kind of a patent thickets, or at least where people are not sure whether they can operate. And one of the issues is that they have these so-called patent trolls, which essentially you can patent a process that might be to some people it might be seen as like something that somebody can do in person, but they implement it on a computer. For instance, booking online travel or using a fax machine, and a lot of these patents. The issue is that they were filed relatively early before this kind of thing was implemented on the computer, and then for whatever reason they got through the patent office, and it might be just due to the patent office being overworked that some of these things tend to slip through, and the issue is that these can be bought up by so-called trolls, which they also call them non-practicing entities. And then they do a large enforcement campaign. They might actually sue smaller companies as well, and kind of ask for a payment that's small enough that they wouldn't actually necessarily get legal advice. and just pay kind of go away money. And then to actually suing much larger firms, and it's particularly an issue in the US because you can get these lawsuits for hundreds of millions of dollars just for patent infringement. And the main issue is, especially, this is the scary thing for large companies, is that they might have a huge patent portfolio that they can use, and that tends to stop the larger companies from suing each other. Apple and Samsung are a bit of an exception to the rule, but that tends to stop companies from suing each other. But with these so-called patent trolls, they're not actually doing anything; they're just holding patents. So you could have 1,000 patents, and it's pretty much ineffective against these companies because you can't counter-sue them. So it was a bit of a kind of growing kind of business model, and there's been some reactions to this. There's a company called Intellectual Ventures, and they essentially go around and buy up as many of these patents as they can, typically software patents, and to get them off the market, as it were. And but some people might see them as just being another example of the troll phenomenon, because they go around and then seek to license their portfolio as well, but presumably for a smaller fee. So yeah, it's an issue, and it's a risk for companies, especially that are going into the US. There's been a little bit of a pushback from the Supreme Court recently, the Alice case, and that has put a lot of these software patents into doubt. So there's a bit of a pendulum swing back away from software patents, but it's still it's a bit of a risk, and it's definitely still possible to obtain a software patent. It's just slightly more geared towards a technical solution rather than these kind of what they call business method patents, or where you're essentially patenting a process of doing something that could be done offline, but you're just implementing it on a computer in a trivial way. But perhaps it's a way that hasn't been done on a computer before. So I hope that kind of...
No, it's fascinating. I mean, as I say, I wasn't aware of this phenomenon until quite recently. But I mean, the key is obviously to bring in some expert advice, but also to just double check, I guess, on Google Patents, if nothing more, that your idea isn't one that's been captured already in some form or other. Would that be fair, or
yes,
is that simplistic?
I mean, doing a freedom to operate search is especially if you are in a particular niche, that's important. It can be very, very expensive and difficult.
Yeah.
And it is, but it's always something. It's always a risk. Your best bet is to try and see if something's definitely been done or before, but and then that patent has expired. But it is something that a lot of companies have to deal with, and it's just perhaps cost of doing business.
Yeah, sure. Sorry, I promised you, Savva, before we started this, that I wouldn't throw a curveball in, but I did there with that. It just suddenly sprang to the front of my mind, so apologies for that.
Sure.
Yeah, it's an interesting subject. So more generally, you were explaining about the work in patents, and because the other question I was going to raise actually, it just in your early comments, was how I think entrepreneurs generally can woefully underestimate what is IP within the business and what does need protecting.
Yes, yeah. So there is a bit of confusion. People tend to confuse things like trademarking and patenting things. They tend to think that you can trademark your brand and you can or you can copyright your brand name. That you can copyright your brand name versus trademarking it. So in general though. I'm a big fan of trademarks. That's really a way, and that's the main way to protect a brand. And also you can protect a slogan with a trademark. The downside with trademarks is that they only have local effect, so you've got to file them in individual countries. People often don't realise that. They think, oh, I can get a trademark in the UK and then that will protect me. Mm-hmm. But actually, if another competitor, maybe in Germany or the States, sets up, they can get rights to your name over there and prevent you from expanding into that market. And so that's something that entrepreneurs do need to be aware of. It's a relatively cheap way of getting protection over your particular brand, and I particularly like trademarks because they can protect the kind of secret sauce or the kind of the services that you provide that are associated with your brand, and if you have a very good service, you can sort of get almost like a monopoly over that particular idea, at least in the consumer's mind, which associates that particular service with your brand. So in a lot of these other forms of IP, say for instance your customer service model, you might not be able to protect using traditional forms of IP like copyright and definitely not patents. So a trademark is a good way to protect those. And copyright is something that does come up particularly around where you are creating a lot of content where there's user-generated content that you need to make sure that your users aren't taking copyrighted material from other places, and you need to make sure that where you do use other content, that you have licenses in place, particularly for software companies, where you have a developer and they might take some code from somewhere else and might not have been theirs, or it might have a restrictive type of license or a kind of license which they call an open source license, which essentially means some particular kinds of open source license, particularly the GPL license, means that you have to release your source code to everyone once you've used it. But there are some issues around there, and your programmers, your developers don't necessarily read licenses before they use software. So that's an issue around protection and the other thing is around, particularly when you are developing things and you're creating new IP, one of the main issues that entrepreneurs need to be aware of is that when they have somebody else doing the development work, that they own that IP, and they need to have something in writing around that. Otherwise, they'll get to the point where they might not even own the IP that they've paid for, and they might just have a license to use it that could potentially be revoked. And finally, there's trade secrets, which essentially like where you're protecting your own some process which you can create a certain output, and you need to have contracts in place to ensure that the people working on that process don't disclose it to others, because once it's out there, you've lost your trade secret protection everywhere in the world. So it's trade secrets is quite a risky strategy, but it's one that it can be managed through having a trade secret strategy and making sure that few people are really aware of how your own processes work.
Well, listen, that's really interesting. I was actually, my ears pricked up a little bit with that comment you made just a while ago about making sure if you have developers that you own the IP. I was involved in a business 10 years ago now. So in my lifetime, certainly the early stages of my understanding of websites and who owned things, and we had exactly that situation. We had a developer who developed quite a nice little idea, and then we hadn't quite picked up on the fact that they had kept the IP for themselves, essentially the domain name, frankly. So we had a little bit of a small battle getting that back off them just through our own oversight.
Yes, yeah. So I mean, it's a very common issue, yeah, definitely, and you do tend to find that especially in that space, developers tend to want to use. They've sort of built up their set of libraries and they reuse it again and again, and in some cases, so you might potentially have other people's IP in there. So it can be a bit of a risky area, and you need to make sure you do your due diligence around that space. Yeah.
Well, listen, that's really useful, and we're going to obviously put a link on our website with this podcast about getting hold of you, Savva. And as a member of our panel, it may well be that many of our customers will encounter you anyway through our process. So thank you very much for that insight.
No worries. Okay. Excellent.
Thanks,
okay.
Savva. Take care.
Andrew. Yes.
Cheers. Bye bye.
All right. Bye.